Judge Sue Opper,
Leslie Daisy, and Zach Witchow, all appearing for the state of Wisconsin.
Sir, state your name for the record, please.
I'm here as a third-party intervener in that matter, appearing as authorized representative for my client. I accept for value and return for value all the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments. Also, Your Honor, I would like to make an offer for my appeal, if I may.
I'll get to that momentarily. The record will reflect that the individual known to this court to be Darrell Brooks is appearing in person in custody. We are, of course, outside the presence of the jury today. Since they are not here, we are dealing with some housekeeping type of issues.
I do not consent or identify by the name that you stated earlier. I want the record to reflect that, if I may.
The record will reflect. Thank you. I instructed my staff to make sure ample copies of the subpoena forms were provided to you. I did receive verification that those were hand delivered. Did you receive those, sir?
No, I did not.
We'll provide additional copies. Again, it's my understanding those were hand delivered. Mr. Brooks, I believe you were requesting 6 subpoena forms. I'm going to have my clerk print out 10 so that you have ample copies. And when that is done and those are handed to you, I'll make a record of that.
Will we address the inmate communication form I sent about the...
I have a number of issues I need to address, so yes, we'll get to that.
You don't believe that has that's an important issue that should be taken up before we continue any further in the proceedings?
I just want to make sure the state has a copy of what was forwarded first before we take that up.
Your Honor, I respectfully would like to state for the record and would like the record to reflect that I believe that this is an issue that should be addressed at this point before we go any further.
Preparing to do that. After receiving the inmate communication form from Mr. Brooks requesting an adjournment, for the reasons stated in that document, I thought it important that we all have before us the current county protocol related to COVID-19.
Now, I decline to accept that if I don't believe
Sir,
that
it will be placed on your table, but I will be referring to that today, so it's been given to you.
Is it verified law, Your Honor?
Attorney Opper, do acknowledge that the COVID-19 illness reporting protocol was provided.
I respectfully object.
yes, Judge.
Your Honor, I would like an answer to that question if I may. As I have not consented to or agreed to accept any paperwork that...
Sir, it's been provided to you. It's
So
something I'm going to consider. You don't want to read it. You want to disregard it. That's your choice.
Are you making the judicial determination that you don't have to answer that question I just asked you, Your Honor?
Mr. Brooks, the COVID-19 protocol has been placed in front of you. It is your choice whether you want to review it or not. So my understanding, just from the information Mr. Brooks has provided, which is part of the public record, is he is requesting an adjournment of all proceedings due to learning that he's on a COVID-19 protocol. I don't have any other information than that, sir.
That is very easy information to obtain.
Sir, I have an attorney for the county here who will verify that none of that information has been provided to me due to HIPAA requirements. So I'm not arguing it with you, sir.
I just want you to know that I'm not arguing with you either, but I was right in the middle of finishing what I was saying.
So I need to stop you for a minute, Mr. Brooks,
I don't
because
consent to that, Your Honor, because
you don't have to consent,
I
but
don't
here we go.
consent or agree
Let
to
me,
being cut off right when I'm trying
all right,
to
I'm just
provide
gonna
the
talk
court with
over him for a
information.
minute. I do not have any other information regarding, the COVID-19 protocol, meaning anything specific about you, Mr. Brooks, other than what was put in the inmate communication, which reads, due to just learning I'm on COVID-19 protocol, I respectfully ask for all proceedings to be adjourned at this time, which is why I asked you if there was any other information you wanted to provide me as I consider your request, because the jail has not provided me with any specific information.
That is incorrect, because just yesterday you were trying to obtain the witness list that was in my cell. You had no problem whatsoever having the JA come down here to have me verify that they can go in my cell and search for that. So I find it very hard to believe that you can't consult with jail staff for them to tell you what is going on in my situation, where they know that I've just been seen by a nurse that placed me on this protocol for having a loss of taste, fatigue. We're talking about someone's health that can affect not just you, but anybody else, not just officers, but also inmates. We're talking about health and we're talking about safety. That has a lot of merit. And frankly, Your Honor, I'm afraid. I'm fully vaccinated and I've never had COVID. I don't know what I'm looking at here. That was the last thing I was hoping I would be told today, Your Honor. So I'm afraid right now. I'm not feeling well. I don't know what's going on with myself. That's the reason why I put in the sick call slip initially. I had been telling officers for days that I hadn't been feeling well, but I didn't know what it was. But I felt that I had to put in the sick call slip because I was not able to taste anything. That is the reason why I was seen by nurses. That is the reason why the COVID test was administered, and that's why I'm on the protocol as we speak.
Are you willing to discuss with me what tests were done? Again, I cannot obtain that information on my own.
I'm not a nurse, Your Honor. I mean, why can't it be verified with the nurse?
I have to verify it with you. The nurse will not provide me with this information.
But the jail can, because they control the movement. They control all inmate movement. I can't just go from my cell to a HSU.
Inmate movement is not the issue at the moment.
It's not, but I'm saying the jail itself controls the movement of the inmates. That's common sense, Your Honor.
I'm not here to talk about inmate movement at the moment. What I'm asking you is, do you believe you were tested for COVID?
I obviously was tested for COVID. I would not be on the protocol if I was not.
Do you know what type of test? Was it an oral swab, a nasal swab?
It was a nasal swab.
All right. Do you know when the results of that test will be back?
From my understanding, Friday. That's what I was told by the doctors. I would have to be at least on this protocol until the results come back, which he said the earliest would be Friday.
Were you offered a rapid test?
They said they do not do the rapid test.
So you weren't offered a rapid test?
They said they don't do them. Frankly, I'm very afraid right now because I don't know what's going on. This is new to me. Like I said, I'm fully vaccinated, Your Honor. I've been fully vaccinated since 2021. And so for this to just be sprung on me now to say this could possibly be a COVID thing, I've had people close to me that have passed away from COVID. I'm afraid as hell, Your Honor. That's the reason why I submitted the ICF for the adjournment. I was thinking at least until I can get the results, at bare minimum. I don't think I'm asking something that's impossible for Your Honor.
If I can make arrangements to have a rapid test brought to you and administered, are you willing to submit to that test?
Not at this time.
Why not?
Not at this time.
Why not?
Why can't I get the results for the test I already took?
But you're telling me you're scared, you're
Yes,
fearful?
I am.
But you
am
don't
very.
want to take a test that might
I
tell
took
you today?
I took the test that he gave me.
And
if
you're
he
telling
felt-
me that test result won't be available to you until at least Friday.
At least Friday, that's what I was
So
told.
tomorrow.
I was told that I would be
Sorry,
placed
day
on this
after.
protocol until the results came back. The earliest that the results would be back would be Friday.
So that sounds like, to me, I think that's what they call a PCR test.
I have no idea, Your Honor. I
Okay.
have no idea what it's called. Like
Let
I
me
said,
ask
I've
you-
never had COVID. I don't know the test names. I don't know what they call them.
I'm generally familiar with some of the testing for COVID, and I'm asking you once again, if a rapid test can be obtained, are you willing to take a rapid test?
How would that be obtained? How would it be obtained?
I would
was
work
told,
with-
I can only go by what was told to me, because when I was brought in there and they told me that they had to test me for COVID, I was immediately like, what do you mean you have to even test me for this? What is this about?
Well,
I had
didn't
a
you
lieutenant.
report symptoms to them?
Excuse me, Your Honor. I had a lieutenant and 2 officers present when I was asking all these questions. Why do I need? What's going on with this? Why is this? Why is this? Why is that? Because I didn't understand. Immediately in my head, I started to get afraid when they said they had to even test for COVID.
Well, were you reporting being sick and symptoms prior to them asking you to test?
Yes, I've told multiple officers. I didn't know what it was at first because it started with fatigue, with me feeling very fatigued. And I said, man, I don't know if it's just me being tired, or that's what I initially thought it was. Maybe I'm just a little exhausted. But I said, no, anybody knows their body. I said, this got to be something more, because I'm really, I don't even have an appetite. Then when I'm trying to eat, I can't taste anything. That's what said, okay, now I need to put the medical sick
When did
card
you
slip in.
report these symptoms to the medical people or to even just a correctional officer?
A few days ago. Over the weekend is when I started to notice the fatigue. So I was telling officers, man, I don't feel good. I don't know if it's just I'm tired. Usually I don't just jump the gun and say something's wrong, because it could be anything. So
When did you report the loss of taste?
I reported the loss of taste last night.
At the moment, I told you this earlier, you're not within 6 feet of anyone else in this courtroom. And I believe that provides ample protection for the other people in this courtroom. As I consider this request, you've provided information to the court. You've been able to tell me the symptoms that you are reporting, your understanding of the protocols. Despite you reporting fatigue, I don't know if you're standing or sitting on the chair. I can't quite tell. It appears like you're standing, but maybe leaning over the table.
I got a knee on the chair.
Oh, knee on the chair. Okay, but you've been able to very clearly, coherently make your position known to the court at this time, and I appreciate that. Let me ask Attorney Opper if there's anything you would want to provide or state at this time regarding this request.
Yes, Your Honor, a couple of things. Number one, we believe this is nothing more than a further delay tactic by Mr. Brooks. I can advise the court, as an officer of the court and as an offer of proof, that he is.
How could
Mr.
that?
Brooks, did
how
you
could that
hear
even?
Attorney Opper interrupt you when you were talking?
Well, I respectfully object to
You
that.
can object, your objection's noted, but you need to let her state what she needs to state. I will give you an opportunity to respond. I'd
That's
encourage you to use
that is
paper and a
ridiculous, Your
pen
Honor.
to write down. That's the rules of decorum in the courtroom, sir. We generally avoid interrupting one another. That is a sign that we all understand that this is a place of dignity. It is a place of respect. So I will give you an opportunity to respond, but you need to give Attorney Opper an opportunity without interruption. Go ahead, Attorney Opper.
Thank you, Your Honor. Your Honor, again, we believe this is a delay tactic in line with the defendant's behavior since about the August 25th or 26th motion hearing. I can advise the court, as an officer of the court, that Mr. Brooks has been saying for the last several weeks in his recorded jail calls to his mother and others that he's going to get this trial delayed or adjourned or pushed back. This behavior, again, on the 11th hour is 100% consistent with that. I believe that if the court wanted more information from the jail administrator, she is present and could provide that information. I believe Mr. Brooks has waived any HIPAA privacy rights he may have in that regard and indicated that to the court. The fact that he claims to have started reporting symptoms as far back as the weekend, we're probably right up against the 5 days right now. If he started this on Saturday, which I don't believe there's any record of, we're at 5 days right now. And certainly the court's offer to...
I never once said...
Mr. Brooks,
I never
have
said...
an
I never,
opportunity
no,
momentarily.
No,
You
I
need to stay
respectfully
quiet.
object to that because that has no merit.
Mr. Brooks,
I-
it's not
she's
your
saying-
time
no,
to speak.
No, I respectfully object. I never reported saying what day. I never said a day. And if she's saying she has jail phone calls, well, why aren't they present? Why can't they be verified by sworn affidavit and brought into this court to be shown that this is a delay tactic, as you say it is? How come it can't be shown by sworn affidavit? Can you provide proof of that?
All right, Mr. Brooks, I've given you a little
Just
bit of
like-
leeway
just like you're
because we
saying
are outside the
that I've
presence
waived
of the
something.
jury.
I haven't given consent to waive anything. I've simply told the judge that I had no issue with her verifying with the jail that this protocol is in effect and that I was in effect tested for COVID-19. How could that be a delay tactic? If that was a delay tactic, why would I even need to be tested and placed on the protocol? Why does everybody have to have on masks to bring me down here?
All right, Mr.
Is
Brooks,
there no-
I've
is there
given
no
Mr.
verification?
Brooks, I'm going to warn you now that you have interrupted a couple of times. You interrupted
I have to
Attorney
be able-
Opper
I have to be
twice.
able to speak up,
You're
Your
now
Honor.
interrupting me yet again. We all were polite and had you provide
was not
information.
polite. That was
That's
abuse.
at least the
that was
third
abuse.
interruption of this court.
That was abuse by the prosecution. That was abuse.
Mr. Brooks, let me finish.
No, because that's
So he's outright refusing to listen.
I would
He's
not sit
outright
here.
talking over me
I didn't
at the
refuse
moment.
anything. I didn't refuse
Mr.
anything.
Brooks, we are at
I'm
the
not-
point
I'm not gonna-
yet
I'm not
again
gonna
where I
sit-
will put you in the other courtroom because
And
you
I
are
don't
not
consent.
able.
I don't consent to being removed. I have not waived the right to be present, and I don't agree with that.
Mr. Brooks,
Does the
I
record
have
reflect?
provided
does
you
the-
on multiple occasions and it's should be in front of you,
No,
and
I
if
don't.
not,
I don't acknowledge that. I haven't agreed
you
to
have been
it, and I
advised
haven't
on
given
multiple
consent of it.
occasions that you need to abide by the standards of courtesy and decorum for the courts of Wisconsin. Because you are a litigant, you're both a named defendant, you are now acting as your own attorney by
I'm not a named
representing
defendant.
yourself.
I don't recognize the name
That all of the
the
rules
states
of courtesy and
put on
decorum
their
apply
complaint.
to
I don't
you.
recognize that name.
I need to warn you that further interruptions may very well result in you being removed to the other courtroom where you would participate by audiovisual means. From the jail administrator, thank you very much. And just to get some general information and perhaps even some specific information regarding the what Mr. Brooks has provided, since he indicated I could verify all of this information with either the lieutenant or others who are present. So I believe we have Angela Wallenhopt here, if she would come up to the witness stand.
Your Honor, if I don't want to mix issues, but the inmate communication form from September 28th also still needs to be addressed by the court, and I think the jail administrator may have some information relevant to that issue as well.
All right, thank you.
Please.
I have a list of a bunch of things I want to go over, and I'm gonna.
So, Your Honor, respectfully, just so I'm clear, are we addressing the issue at hand now?
We are.
Or are we addressing something from September?
Well, I will get to the September inmate communication form at some point during this hearing, but right now I'm addressing the most recent inmate communication form that is dated October 5, and that addresses your request for an adjournment.
Judge, I have not reviewed his medical record prior to arriving here.
All right, fair enough. Do you have an understanding of what that is?
Yes,
Based
however,
on information provided to you?
yes, however, he has not signed a release allowing me to speak to the court. So if you are ordering me to speak to the court, I can speak to what my understanding is.
Mr. Brooks, I took your statements earlier that you would not object to me asking jail staff about the current situation to verify the information you provided. Is that still correct?
I said that I wouldn't have any issue with pertaining to myself. I don't know. I'm not speaking about anybody else in the jail. I'm not speaking about what everybody's situation is different.
Right, and I'm specifically referring to your situation.
Well, the question was asked in how does it pertain to me? It was pertaining to me, all the questions, which it came up when I said that there was a lieutenant and there were officers present when I took this test from the nurse.
Right, I'd like to verify the information that you're providing to me regarding what was reported by you, what tests were administered, and why you're on the protocol with the jail administrator. First of all, do you understand what I want to ask her about?
No, I do not understand.
Did you hear what I said just now?
I do not understand.
But did you hear what I said?
Frankly, Your Honor, I think she would probably be the wrong person to be asking because she wasn't present.
You must understand then what I'm saying if you think she's not the person who would provide that information.
I don't understand. I didn't consent to understanding or agreeing to that. No, I do not understand.
All right. I took his statements earlier. I realize you don't have a written waiver as to be a verbal waiver of any privacy rights under HIPAA, and I am directing you to answer the question.
Okay. It was brought to my attention shortly before the lunch hour that he had made statements that prompted the medical department to follow up. As I said before, I have not reviewed the medical record. It is my understanding he was administered a test. He was also offered another test, to which he refused.
Do you have any information regarding whether this other test would have been a rapid test?
I believe it to be.
Do you have those tests available in the facility to offer to an individual?
I have one available right now.
Can I ask a question, Your Honor?
Of me or of the witness?
Jail administration.
Go ahead, you can ask a question.
Ms. Wallenhoff, if there were different types of tests available, why wasn't I administered the correct test when I first was tested? Why would essentially I would be asked to take a test, take that test, then turn around again and be told to take a whole nother test? In my mind, that's almost like some type of ploy or something, some type of scheme. Why?
Sir, what's the question?
I asked the question, why would I not be given the correct test from the get-go instead of having to take two tests? If I've already taken one test.
You have to give her an opportunity to answer, and you gotta ask one question at a time.
I just asked the question.
Can she answer it then? Do you want her to answer it? I presume you do, since you asked the question, so you need to stop talking so that she can answer it, okay?
Limit your abuse, Your Honor.
I'm sorry?
I don't appreciate being talked to that way, Your Honor.
Your objection is noted. Go ahead and answer.
Judge, I would prefer not to answer that question. He states the wrong test. I don't know what he's speaking of. I have not reviewed the medical record with what test was administered, so I would prefer not to answer that question.
All right, fair enough.
I did not say the wrong test. I said two tests. If it was, why would I need to take two tests for the same symptom?
Your
Your Honor, I object to relevance and beyond the scope of this witness's knowledge, and it also assumes a fact, not an evidence.
I didn't have clarity on the answer to that question. Essentially, what I'm asking is, why would I need to take 2 tests for the same thing? There shouldn't. If I'm taking a COVID test, why would I need to take another one?
I'm going to object as to lack of foundation and beyond the scope of this witness's knowledge, Your Honor.
The objection is sustained. I'll direct the witness. She does not need to answer that question. Next question, if you have one, please.
I still don't have clarity on that, Your Honor. I'm baffled.
Do you have another question? A different question?
Would it be any way to verify why I would need to take 2 tests for the same symptoms?
I'm not sure I understand the question, sir. I think
I'm referring to the nurse who administered the test.
the nurse isn't here, though. This is Jail Administrator Wallenhaupt.
And that's why it's hard for me to wrap my head around why Mrs. Wallenhoff would be called to testify when she was not present. I think the wrong person is testifying.
Do you have any other
Because
questions
the
for
reason
her?
why I
I
say
understand
that-
what you're saying. Do you have any other questions for her, though?
Are you sure you wrapping your head around what I'm saying, Your Honor?
Do you have any other questions for this witness?
To your knowledge, you just said that you have a rapid test available right now. When did that become available? Because I was told otherwise.
I know there is a rapid test available right now. As I stated before, it is my understanding that you were offered a rapid test and you refused.
So why was I not offered a rapid test from the get-go?
Objection, relevance.
If she knows, she may answer.
I do not know the answer to that. I have not reviewed the medical record, jail contracts with a medical provider.
Thank you. Next question, if you have one.
So there are more than one type of COVID test administered by this jail.
Again, the jail contracts, Judge, I prefer not to answer that. The jail contracts with a medical provider. I do not direct testing.
I believe the record's clear that a rapid test was offered. It was declined by Mr. Brooks. The record's also clear that
I
he did
object to that,
submit.
Your Honor.
He did submit to a test. To further answer it might be speculative. So, do you have another question?
So would it be fair to say, you just said it would be speculative, so would it be fair to say that it'd be speculative that the second test would be a rapid test?
I will make a determination on your motion after all of the evidence and testimony on this issue is received.
Is that an answer,
I can't
Your Honor?
answer that question at this
Well,
time,
I'm
sir.
asking it of Ms. Wallenhoff. Is it because we just said it would be speculative?
Well, you
So-
were looking at me when you said that,
Well,
so are you, and I'm not gonna answer that question. I'm not a witness in this.
The
I
reason
make
why
the
I was-
determination
The reason why I was
ultimately.
looking at Your Honor is because
Do you have another question
I'm
for
still trying to
Jail
figure out
Administrator
how-
Wallenhaupt?
I thought testimony was supposed to be the prosecution and the defense's time to ask
Sir, do you
questions.
have another question? Otherwise, I'm gonna ask the state if they have any more from this witness.
I asked the question, would it be fair to say that it's speculative about what the second test actually was?
Mr. Brooks, I don't understand your question.
What isn't to understand about it? If you were offered a test,
Objection, relevance.
no, it's a question.
Hold on.
I'm
You're
getting some-
asking a
I'm
hypo-
going somewhere.
I'll let you get the question out, but I would just note you're asking her a hypothetical that, given her role, she might not be qualified to answer. But you can go ahead and ask it.
Well, it's not hypothetical. It's very logical. if you were offered a test and you took it, why would you need to essentially take another test that could have been done right from the beginning? If there would be any issues, if there would be
All right, Mr. Brooks, it's not relevant what she would do. So that's essentially an argumentative
Okay, so
question,
why
and it's
would I
not
do it?
relevant. So
Why would
sit
I do it
down.
then?
You're done asking questions because you've
so
now
is that
asked.
a judicial determination?
I haven't made a judicial determination yet.
You're
Go ahead,
practicing
Attorney
law from the
Opper.
bench by being able to ask
Mr.
certain
Brooks.
questions of yourself.
Mr. Brooks, okay, here's your warning. I'm giving Attorney Opper an opportunity
So
to
you're
ask this
practicing law from
witness
the bench.
questions, and if you interrupt her, you will be removed to the next courtroom.
I don't consent to being removed to the next courtroom. I don't consent to even being at these proceedings if I'm not able to put on a proper defense, which is my constitutional right to be able to do so. I haven't agreed to any contracts. I haven't consented to any contracts, and I have
Your
not
objection
consented-
is noted. Attorney Opper, go ahead.
I have not consented
Thank you.
to
Ms.
an
Wollenhop,
estoppel either. Jay, for relevancy.
to your knowledge, are those
Hold on.
materials?
The objection is overruled. Go
I'm
ahead.
sorry. To your knowledge, if you know, are his discovery materials currently in his jail cell?
Yes, ma'am, to the best of my knowledge.
Okay.
I object to
Is
that,
he
Your-
still
I object
able-
to that, Your Honor. I'm not allowed
Sir,
to
her
keep.
answer stands. There's no question to which to
I
object.
object to that. There is.
You can't testify at the moment. If you want to provide further information after she is done testifying, I will give you that opportunity.
Will she?
Your
will she be
objection
able to-
is
Will she
overruled.
be able to stay right there so I can ask the question?
It's not your time yet. You have to wait. So this is the final warning. Okay, I've given you a lot of leeway today.
You have not, Your Honor. You haven't. No.
I
you
am
haven't.
turning to Attorney Opper. It is her opportunity, her turn to ask this witness a question.
And it is my right to be able to object, just like she objected
And-
when I was asked the
Right,
question.
and when the court rules on an objection, usually the party who objects stays silent. I rule on the objection. The parties don't debate the ruling. It's noted for appeal. And then we move on.
Then I would like to put you on notice that I will be appealing that judicial decision that you are making.
Next question, Attorney Opper.
The judicial determination.
Ms.
rather,
Wollenhop.
that you are making.
While on COVID protocol, does Mr. Brooks have access to the tablets in his jail cell?
Yes, ma'am.
And that tablet has legal materials available for him to access if he so chooses. Is that correct?
Yes, ma'am.
And while he is on COVID protocol, does he have access to the conference room, which also contains a computer with further legal materials?
Yes, ma'am.
And nothing about the protocol would restrict his access to any of those materials. Is that correct?
Correct, ma'am.
And you've
I object to
indicated
that. I
previously.
object to that respectfully, Your Honor.
So, an objection goes to whether there's lots of rules of evidence that
That's it.
apply. But if you're objecting to her answer, that's a different thing. You can argue
I'm
the meaning
objecting
of
to
that
the
later.
question.
Okay,
not
the
the
objection.
answer.
But then you have to say objection before she answers. You
She
objected
didn't
after
answer.
she
She
answered.
didn't answer the last
The
question.
objection is noted, it's overruled, her answer may stand. Next question.
Ms. Wollenhop, you're aware that there has been digital discovery made available to Mr. Brooks for him to view in the Waukesha County Jail,
I
correct?
respectfully object to that.
Overruled, she may answer.
Correct.
He would view that digital discovery on the computer in the conference room in his pod,
I
correct?
respectfully object to that.
Overruled, you may answer.
Correct, ma'am.
And
So you're gonna
the
overrule
proto-
everything, Your Honor?
All right, Mr. Brooks, you have got to stop. It's fine if you object. I will rule on it as I deem appropriate under the rules of evidence, which, by the way, I provided a copy for you. See that big book over there?
No, I don't
It
see
has
it.
the criminal statutes.
I don't see it.
It has the traffic code. It
I
has the
don't see
rules
it.
of evidence. Well, it's on your table. It's behind the microphone, and it's there. I've provided it to you as a courtesy so that you have that available
You did not
to
provide
you.
anything to me.
All right, I'm
Something
directing the
that-
bailiffs to
something
remove
that
him
may
to the
have-
other courtroom.
something
I've
that-
provided ample opportunity
I've
for
never-
Mr.
I've
Brooks
never
to
taken
abide by the
anything-
simple
I've
rules
never
of
taken
decorum
anything,
and
Your Honor.
civility.
Your Honor, I don't
He is-
consent or agree to what you are doing.
Your lack of
don't give
consent is
consent.
noted for the
I
record.
don't give consent to an estoppel. I don't give
I'll make
consent.
a more full record when we
I
are
don't give
open
consent
again to
an
the public.
estoppel. I don't give consent to be removed.
Madam
being
Reporter, the
able
record
to
should
exercise
reflect
my
the court is
constitutional
stepping
right.
off the bench. You may step off
I
if you
move.
want.
I move for a motion to dismiss. You still haven't even ruled on the claim. There's no one that even has a claim against me here.
Mr. Brooks is muted, so I can appropriately make my record here today. I will promise to unmute him when we continue with the hearing after I make my record regarding the removal, assuming he can maintain even the simplest of civility. And I do want to initially confirm, I know I could hear him until I muted him. I can see him. Can we please get confirmation from the other courtroom that the audio and visual is working? All right, and we do have confirmation of that as well. I gave him ample warning before he was removed. This court, frankly, has no other option at this point other than to put him in the other courtroom so that I can continue with this very important hearing, a hearing at which he has requested an adjournment of the proceedings. All right, go ahead, Attorney Opper, for the record. The mute has been undone.
In order for him to view the contents of the thumb drive, he'd have to use the computer in the conference room, correct?
Correct, ma'am.
And that is available to Mr. Brooks upon his request, correct?
Correct, ma'am.
And nothing
Hold on
about,
a second. Mr. Brooks, the basis for your objection at this time?
That is irrelevant to why I'm asking for adjournment. I was not asking for adjournment based on being able to utilize the conference room or a tablet.
Your objection is noted. It's overruled. Her answers may stand.
nothing about this protocol then would limit his access to any of his discovery materials, correct, ma'am?
Objection.
Overruled. She may answer.
Correct, ma'am.
And he would have access to the telephone if he wants it.
Objection.
Overruled. She may answer.
Yes, ma'am.
And there would be nothing that would restrict his ability to come to court each day?
Objection.
Overruled.
Correct, ma'am.
And when he comes to court each day, he has the ability to bring whatever discovery materials with him that he wants. Is that correct?
Objection.
Overruled.
Correct, ma'am.
And in fact, there's a card available for him to do that if he so requests.
Objection.
Overruled.
That is correct, ma'am.
He started feeling not well, I believe were his words, over the weekend. And is there any notice to any correctional officer or jail supervisor that you're aware of that Mr. Brooks reported that to them?
Objection.
Overruled.
I have not reviewed the jail medical record. This came to my attention shortly before the lunch hour.
Okay, I guess maybe I'm asking a question I don't know the answer to. If he were to say to one of the officers or a lieutenant,
Hold on a second. Was that an objection? Or just a comment under your breath? Your objection's noted. It's overruled.
Of course. What specific protocols would prohibit being able to shower?
objection, irrelevant.
I'm not gonna, it's sustained. Mr. Brooks, I'm going to honor the request of the jail administrator not to talk generally about protocols, given the operations of the jail, but you may ask her if there's something specific as to you.
Would any protocol that I am on currently prohibit me from being able to shower and or shave?
Do you speak moving forward?
As of right now.
You would be allowed to shower on the protocol you're currently on.
Would I be able to shave?
You would be able to shave.
Would that be with the clippers or a razor?
Objection, relevance.
Overruled. She may answer.
Mr. Brooks, we would monitor behavior and other factors in that and make a determination. There's procedures operationally in the jail that you can request those items. And you
That would be independent of the COVID protocols.
correct, ma'am.
So, to your knowledge, are you aware that we are only permitted, and I'm saying myself as well, being housed in the jail, that we are only permitted razors once a week and clippers only once a month?
Judge, I would prefer not to answer questions in regards to jail operations.
Right. I'll honor the request of the jail administrator. It goes beyond the scope of this hearing. We're a little far field. I gave you a little bit of leeway, but whether you shower or shave would, in my humble opinion, not be relevant to the issue of whether you can assist in your own defense.
Would you care to share with the court on record the types of protocols that I am currently on outside of the COVID protocol?
Objection, irrelevant. Goes to jail operations.
Sustained.
Does my specific protocol change the normal time that I would be allowed out of my cell?
Judge, again, that speaks to jail operations.
Mr. Brooks, unless you have a specific question related to access to your materials, I'm gonna have her not answer that.
To the best of your knowledge, are you aware that there is a certain times that the phone will be available? You have other inmates that,
Let's
have
not
time
talk about other
available.
inmates, but again, I'm sorry for the interruption, but I want to try to get us through these questions. If you're asking,
Okay, let me ask it another way.
okay, go ahead.
Being that because of this COVID protocol, I won't have my usual time out of my cell that I would have regularly, would I be able to utilize the phone in the same manner that I would be able to use the phone had I not been placed on this protocol? Or would it be strictly by me having to just ask?
I guess I'm unclear as to the manner you speak of. What are you referring to?
I think I was very clear with it.
Are you trying to
You
ask
are
her?
aware- Are you aware, which I know you are, that the protocol that I'm on outside of the COVID protocol prohibits me from being able to utilize the phone at certain times of the day? Would the COVID protocol prohibit that any further?
Mr. Brooks, are you trying to ask whether the COVID protocol impacts your phone privileges?
That's what I just said. No, not in a sense, because I think it's more accurate with the way that I asked it.
But your question
Yeah.
assumes facts not in evidence and that are beyond the scope of this proceeding. I'm concerned about what, if any, impact the COVID protocol has on your ability to prepare for this case.
The reason why we're having this didn't have anything to do with limiting my preparation.
So
That wasn't the real issue.
I think it's related to
I just
the,
wanted that clear. I just wanted that clear.
I understand.
That's all. Outside of the COVID protocol, the protocol that I've been on for a very, very long time. So my phone use is limited to certain hours of the day, which works out.
all right,
for
Mr.
my
Brooks, we're
family.
getting a little far field. I need to make a determination on your request. So I'll
Well,
ask you one last,
You haven't let me finish what I
I
was
will,
getting to.
Mr. Brooks, I will ask you one last time. Do you have any other questions for the jail administrator?
Your Honor, what you're doing right now is you're not being fair right now.
All right, Mr. Brooks has not answered. Unless there's any further questioning from the state based upon the additional questions that were asked, then I'm gonna have her step down.
I just want to ask of the court if you're intending to take up his inmate communication form that was dated September 28, 2022 as well, while Ms. Wollenhaupt is on the stand. I just have a few questions related to that, Your Honor.
I object to that, relevancy. What does it have to do with what she's testifying to right now today? They're two separate issues.
I'm sorry, I don't know the document. Oh, I do have the document number, 258.
Objection for relevancy.
Hold on, Mr. Brooks. I need to find the document in my record. 258, you said?
Yes.
I am going to allow the jail administrator to be questioned regarding document 258. So I will print it off in that courtroom so that he has that.
So that I have this correct on the record, you're making a judicial determination to allow testimony of something that has no relevancy to what's being raised today.
I'm going to address it after I address the motion to adjourn that you filed, but since we have her here, I'm going to have the parties question her on that document as well. It promotes judicial economy, and that's my decision. So go ahead.
Can I put Your Honor on notice that I intend to appeal that decision?
Your statements noted of record. Can someone confirm whether that document was given to Mr. Brooks as well? I did print it to the printer over there. I have that ability. It was. All right, thank you. The record to reflect he has also been provided with a copy of docket number 258.
I'm not acknowledging that document, Your Honor. I'm not acknowledging that. I don't consent to any.
All right, I'm going to mute him because he's interrupting. Mr. Brooks, it's a document you filed.
In this communication to the court, Mr. Brooks indicates that he is on a, quote, keep separate, end quote, in the jail, correct?
Correct.
And at the conclusion of the form, near the bottom, the last two sentences, he indicates that he has no access to the materials he needs to prepare for trial because of the keep separate order, correct?
Correct, that's what he states.
Okay. Did Mr. Brooks have access to his legal materials during the time that he was under a keep separate order?
Yes, ma'am.
Again, that would be the banker boxes of written discovery in his own jail cell?
Correct. Anything that was in his jail cell, he would have access to.
Okay.
And he would also have access to the conference room and a tablet.
And the
in his
tablet.
cell.
The legal materials that are provided to him are on that tablet and on the computer in the conference room.
Correct.
And nothing about that keep separate order affected his ability to access those things, correct?
Correct.
Thank you. I don't have any other questions on this topic, Your Honor.
All right, Mr. Brooks, I will unmute you. Do you have any questions on this topic for the jail administrator?
Yes, I do. You just stated on record that I had access to all materials for trial prep during the time of this keep separate, correct?
It doesn't specifically say what you don't have access to, so yes, what was in your cell.
Did you just say in open court on the record that I in fact had access at the time of this keep separate?
2 items in your cell, and you could have access to the conference room to view electronic.
So, am I correct in saying that when you brought over these discovery materials to the pod, that I was in fact in one of those conference rooms and I talked to you face to face, is that correct?
You were in a conference room and we spoke.
And I informed you then that I was on the keep separate, correct?
I do not recall that.
I specifically told you that I was on a keep separate with the guy that was in the cell next to me that had placed that on me, correct?
I do not recall that.
So you don't recall, you can recall that we spoke, but you can't recall what we spoke about?
I informed you at that time I was delivering the banker's boxes.
And I took the liberty to explain to you that I was going to keep separate and that was going to hinder me being able to prepare. Is that correct?
I do not recall that.
You don't recall that, or you don't remember me bringing it up?
I do not recall us having a conversation regarding the keep separates. We had a conversation regarding me delivering your legal material.
So, is there a way to verify when the keep separate went into effect?
Objection relevance.
Well, hold on. Mr. Brooks, is the issue the keep separate protocol, or that you didn't have access to the materials that we've now established through testimony you had access to once they were delivered to you?
Initially why I wrote it was because that stops me from being able to shower in the unit, because officers would have to then take me to another part of the jail, sometimes in the pod, in a secure shower is what they call it, which is downstairs. in
Sir,
another
I'm just
room.
gonna stop you because I honestly, the whether you have a shower or not is not relevant to the issue of whether you had access to the materials you need to prepare for your case. Any questions at this point for the jail administrator? Again, not related to the shower, but related to access to materials.
Does a keep separate protocol, Ms. Wilderhawk, does a keep separate protocol restrict inmate movement in any way?
Objection relevance.
Sustained. Overly broad.
If I am on a keep separate protocol, would that in effect limit me to only being in my cell and being able to only utilize what I would essentially have in my cell?
That's a compound question, so you have to break it down one at a time. So rephrase.
Would a keep separate protocol restrict me to cell confinement until arrangements can be made for me to be able to resume my normal activities?
Judge, I would prefer not to answer that. It's due to jail operations.
Mr. Brooks, I'm going to honor the request of the jail administrator to not answer that because it would require her to provide information regarding jail operations. It's overly broad. You need to limit the question to how this protocol limits you, specifically as it relates to access to materials needed to prepare for trial.
I asked the question and I was told that it wouldn't be answered. I asked at the time that she brought over the discovery materials, was she aware that I was on a keep separate protocol at that time?
Asked and answered.
Sustained. The answer was already provided. She doesn't need to answer it again. Next question.
What was the answer to that?
The record speaks for itself, sir. Next question,
I don't
please.
recall her answering that specific question.
Next question, please.
Can you provide for me where she answered that specific question?
Mr. Brooks, do you have another question for the jail administrator?
Is it going to be answered? Is it going to be honored?
The record speaks for itself, sir.
Well, if the record speaks for itself, then that question should be able to be answered. Were you aware, Ms. Wallahop, that at that time I was on a keep separate protocol? That it was already in the system that I was on that protocol?
What date are you referring to, sir?
The date that you brought over the discovery materials, were you aware at that time, on that date, that I was under a keep separate protocol?
You previously asked me if I recalled a discussion you were informing me.
But that's not the question now, though.
I was aware.
The question is, the day that you brought over the discovery material, were you aware at that time that I was on a keep separate protocol?
I can't state for certain at that moment in time. I was aware you were on a keep separate. I can't state what day that I was made aware of that. I think it was due to a complaint that you sent forward to the jail.
I sent no such complaint. The complaint was by the other party. Were you aware of that?
Judge, I prefer not to answer this. I don't understand how it impacts what he has
Mr.
had
Brooks, we're
access to.
far afield from the issue at hand, so I'm going to ask you one last time, do you have any additional questions for the jail administrator?
What are you allowed and not allowed to do on the keep separate protocol?
Objection, relevance.
Sustained. All right, then, I gave him the opportunity to ask questions. That was his last one.
I wasn't done.
Mr. Brooks, I'll give you one more opportunity then. They need to be relevant. They need to be within the bounds that I've already discussed.
That was in the bounds. I just asked this.
The issue is limited to the impact of the keep separate on your ability to have access to materials needed to prepare for trial.
But Your Honor, with all respect, every question that I asked that had relevancy to that was either overruled or she was directed not to answer that.
Mr. Brooks.
So
Mr. Brooks, you indicated you had other questions. I will give you this opportunity if you can ask a question that falls within the scope that I've previously identified. Do you have another question?
Would I be allowed out of my cell on a keep separate protocol?
It's vague, Your Honor. The question is, was he allowed out of his cell to access his legal materials?
That's not what I asked.
Right, the question you asked, the objection is sustained. If you'd like to ask the question suggested by Attorney Opper, that would be permissible by the court.
No, I would want to ask my own question. Thank you. Was I able to come out of my cell on the keep separate protocol?
Judge, I would prefer not to answer that.
It's beyond the scope of the inquiry right now. The jail administrator need not answer that question.
Can you give me the basis why, Your Honor?
It's beyond the scope.
What does that mean? I do not understand.
Mr. Brooks, do you have any other questions?
I do not understand what beyond the scope means. That was a direct
One last time,
question.
sir. Do you have any other questions?
That was a direct question.
All right, I'm going to mute him because he's now not being responsive to the question that I asked, and that is, does he have any questions to ask the jail administrator within the scope that I've previously outlined? Any follow-up from the state?
No.
All right, thank you. You may step down.
Nothing else from the state, Your Honor.
Mr. Brooks, do you have anything else related to the inmate communication form dated September 28 of 2022? Since I obviously included that after we took up the other issue.
Yeah, I don't understand how any questions that I was asking are not allowed to be answered.
Mr. Brooks, I'm asking you very clearly, do you have any other information, testimony, or evidence you want to present as it relates to the inmate communication form dated September 28 of 2022?
Yeah, I would like to. Is it a way that we can verify the standards of the keep separate protocol?
Mr. Brooks?
To be able to show the
Mr.
court?
Brooks, please listen very carefully. There's a question I'm asking you is, do you have any other evidence?
I don't consent to being asked a question.
Document? All right, then
You can't even answer the
All right,
question
I'm going
without
to mute
asking
him
me.
once again. He is not answering very clear questions. Mr. Brooks is holding up the objection. We're not taking testimony at this time, so the court does not feel compelled to acknowledge that any further, other than to say the fact that he's objecting is noted for the record. Mr. Brooks, I'm going to unmute you because it is your motion to adjourn these proceedings, and as such, I will give you the first opportunity to make your specific request known to the court. I then will give the state an opportunity, and then I'll decide the motion. All right, Mr. Brooks, what is your argument as it relates to the motion to adjourn?
Well, I'm not arguing. I stated pretty clear why it should be an adjournment. I don't think I need to argue anything. I don't think I need to provide anything more. If it's clear to me that the wrong person was testifying. She said that she was not present for the said COVID test. To her knowledge, no way to say for sure why I wasn't provided with the test that I should have been provided with if that becomes an issue. Honestly, Your Honor, I'm powering my way through this hearing. I feel like total crap, to be honest with you. I don't feel good at all. My reason for raising this issue, like I said, was strictly a health and safety thing. It didn't have anything to do with trial prep. It didn't have anything to do with access to anything. It was strictly because, like I stated before on record, I've never had this issue come up for me. Like I stated before on the record, I've had people that I know, loved ones, close people, pass away from this COVID disease. Frankly, I'm terrified because I have yet to even get the results back to say whether I'm positive or negative. I am fully vaccinated. I've never tested positive for COVID. And frankly, to even be told that it's a possibility that I could have COVID, it makes me very afraid. And my intention was to at least be able to get the results back so that I know, okay, I'm good to go. Let's keep the ball rolling. That was my intention. And not wanting to infect anyone else or put anyone else in jeopardy. And also doing the things that I may need to do if I'm found to be positive, doing the things that I need to do to be healthy. That was my concern, and that's why I raised the issue, Your Honor.
Well, Judge, I'm glad to hear Mr. Brooks say this is not a trial prep issue and merely his concern for the health and safety of others. The court has already made the record that we can safely accommodate Mr. Brooks in this courtroom without risking the health and safety of other individuals, even if he should have positive results on his COVID test. We feel comfortable with that as well. The jail can still move him properly. The bailiffs in the courtroom can still respond to his needs properly. So if it's merely a health and safety issue, I believe we've easily overcome that, Your Honor. I don't put much credibility in the comments of Mr. Brooks here. As Detective Regland just advised me, he made 17 attempts for phone calls just this morning alone. So his statement to the court that he was worried about being able to call his family, I think, really is questionable. So I would ask you to deny the motion to adjourn because of the COVID protocol, and to the extent that there was a prior motion to adjourn because of a keep separate order, that also is inappropriate at this time. Thank you.
Thank you.
Your Honor, may I state something for the record?
You may briefly respond. Go ahead.
One of the
detectives that is sitting right behind the prosecutor's desk right now, Detective Casey, just went through something similar with COVID and was not present for a couple of hearings. I don't know how long his protocol was. I can't speak to that situation. It's not my business, frankly. But he wasn't present in the courtroom, and I think that has relevancy due to probably him feeling the same way, not wanting to infect anyone else or put anyone else at risk. I don't see where there's any difference in my situation.
I'm not going to adjourn this trial. I'd also put on the record that he has not been denied access to materials. He has full access even with this protocol. He has had access even to the phone. He would not answer the court's question directly about whether he would take a rapid test. To me, his credibility is at issue with that. If he were truly concerned about his own health and safety, he would want to know immediately, and he repeatedly would not answer that question and instead wanted to debate about what test was provided to him and why perhaps it was not. All right, you're interrupting me. I'm going to mute you. So that is my record here. Today, I agree with the state's assessment. This is nothing more than a delay tactic, given the information that this court, and once again, on the record before me, there is nothing to suggest that he is actively being impacted by COVID-19. I know Mr. Brooks appears to be talking to someone and hand gesturing. Unless he writes a note that he has a topic he wants to address for me at this moment, I'm going to assume he's just directing his commentary to the bailiff that's in there. I will unmute him momentarily to ask him a question, and that question is whether there are any housekeeping issues on his list. All right, Mr. Brooks, are there any additional issues that you believe need to be addressed? Mr. Brooks, can you hear me? Mr. Brooks? Do you have any additional issues to what I've already set forth and the state's added to the list of what I will call generally housekeeping issues, other than perhaps the motion for reconsideration? That's not housekeeping, but.
I was having a side conversation with the bailiff about something, so I didn't hear the last part of what you said.
It's my understanding that the bailiffs would not be having a conversation back with you or at you during court proceedings. So I'll have to confirm or deny that with them. Becky, if you could talk to the bailiff, please.
He was asking how to pronounce a word.
All right, so it's my understanding you were asking the deputy how to pronounce a word. Did he provide a response back to you, Mr. Brooks?
A kind of a response.
What do you mean by that?
It was kind of a response.
Did he provide a response verbally?
I'd rather not say, Your Honor.
I'll have to get clarification from the bailiff later on.
He's coming in.
He's coming in here. Okay, thank you.
He asked me to pronounce what the pronunciation of a word was, and he spelled it to me. I said, I don't know what that is.
Okay, thank you. Mr. Brooks, I'd like to invite you back into the courtroom if you so choose. Would you like to come back to this courtroom, sir?
I never stated that I wanted to be removed in the first place.
My question to you, sir, is would you like to come back over to this courtroom?
I respectfully never consented to being removed.
I will ask one last time before I consider his answer to be non-responsive. Would you like to come back over to this courtroom, sir?
That is not a non-responsive answer, Your Honor.
So the answers provided were not responsive to the question that I asked, and therefore he'll remain in the other courtroom.
So for the record, like that I did not respond. I
The record speaks for itself, sir.
Wish, Your Honor, I'm very tired, so.
Mr. Brooks, we're gonna keep, Mr. Brooks, we're gonna keep going, so please don't interrupt so that we can do this as quickly as possible so you can go back to your cell.
I was just really trying to make the record, which you have denied me to do. As I stated at the beginning of the hearing, I would like to make an offer for my appeal. I've stated that on the record numerous of times yesterday and today as well, and I haven't been awarded that right to do so.
That is not within my authority. That is a reviewing court would decide that, whether that be the Court of Appeals, the Supreme Court, or otherwise. So that's why I'm non-responsive to that, is because there's nothing for me to do as it relates to that based upon the request that you have made. So with that, Mr. Brooks,
Can you verify that by sworn
Mr. Brooks, I'm
affidavit
gonna
that I
mute you,
cannot make?
okay? Mr. Brooks, you've now earned the mute button once again. You have a total number of convictions for Mr. Brooks, and the number that you would ask be the number he answered the question to. Should he testify, have you been convicted of a crime, and if so, how many?
Yes, Your Honor, we believe the answer would be 12, with the first 3 coming from the state of Nevada, and then the remaining convictions all in the state of Wisconsin, mostly from Milwaukee County, but also 1 conviction from Wood County and 1 conviction from Manitowoc County.
So, Mr. Brooks, not going to address this today. The state's putting you on notice that if you elect to testify in this case, they will be seeking a ruling on whether you may be asked, have you been convicted of a crime? And then the follow-up, if that answer is yes, is how many times?
I do want to just say one thing, and not to that. I just wanted to state one thing on the record, that I did inform the bailiffs that I did not wish to accept the paperwork that was brought up by the detective. I don't know his name, so I don't want to be disrespectful. And
The information I have is Detective Ragland did personally serve you with that. He'll file the appropriate service if need be. Whether you take that paperwork with you or not back to your cell is your decision, sir.
well, I just wanted to put that on record that I'm not accepting the paperwork.
Your objection to the paperwork is noted.
I did have another question about, in the event Mr. Brooks has forfeited his right to be present in the courtroom and has been removed, how will cross-examination proceed?
Well, I've reviewed the case law, and one of the possibilities is that he forfeit his right to cross-examine. If he's not in this courtroom, it can be challenging to facilitate cross-exam. And if he's able to abide by the rules of decorum and civility, and whether it be even objections, right, or cross-exam, I mean, that can be shut down, for lack of a better way of saying it.
I understand that, and I know this court has been more than patient. We would just ask the court for its continued patience. We want Mr. Brooks to be able to confront and cross-examine his accusers. He has demonstrated on the 2 occasions so far that we've had testimony, he's quite efficient at asking questions, and so if he is calm and cooperating and not rude and disrespectful, we believe he should be given the opportunity after every witness to cross-examine. Even if he's in the other courtroom, we should at least make that inquiry, unless it becomes absolutely not an option because of his conduct.
I would agree.
Okay, thank you.
So, just so I understand, because I don't, how can I forfeit my right to actively and effectively participate in a trial if I have to constantly be put in a separate location? How will I be able to see everything that is going on in the courtroom? How will I be able to effectively put on a proper defense?
Mr. Brooks, I direct your attention to Illinois versus Allen. That's the case that I've been relying upon regarding your removal. That's found at 90 Supreme Court 1057 from 1970.
That's all I understand, the Supreme Court, the federal court.
That is the Supreme Court of the United States of America.
Is that federal?
That is the Supreme Court of the United States of America, sir.
I'm just really seeking to understand, Your Honor.
Sir, that is
I
the
don't
Supreme.
understand, so
Sir, I've answered the question.
you have, but I still don't understand. That's why I'm asking the question. I'm not disputing it.
Sir, I'm not going to explain the law to you. I cannot do that.
I'm not asking you to. I'm asking, is that a federal court?
All right, I'm going to move on to the next topic.
I still don't understand. How am I expected to do everything in a legal basis, in a legal manner and everything when I keep informing you, Your Honor, on record, in open court, that I did not understand, that I still have yet to understand the true nature and cause of the charges against me, which I don't understand. There's so many things that I do not understand that I keep explaining to you, Your Honor, that
Mr. Brooks, I'm going to refer you back to document number 244, which is the waiver of right to attorney form that you willingly, knowingly, intelligently, from my perspective, understandingly filled out. Let me make my ruling, sir. Do not interrupt, or you will be muted. All right?
just mute me, Your Honor.
So from my perspective, sir, we clearly went through not only this form, but really the topics that are referenced in this form, the advantages of having an attorney represent you, the disadvantages of representing yourself. I honored your request to represent yourself, and it's a bit disingenuous to now say you don't understand what you did. So we're going to keep going. I need to go through some other topics. You are not muted, but there's nothing for us to discuss at the moment.
I'm not trying to discuss anything. I was just letting you make the record, which I haven't been afforded the opportunity to make the record when I offered for my appeal. Again, I do not understand, and Your Honor, I think it's very unfair for you to say that you're finding that I understand. How can you tell me what I understand and what I don't understand? I've clearly made that very, very clear that I don't understand. And the same document that you referred to that I filled out specifically crossed out the word understand. Why did I do it like that? Because I do
All right,
not
Mr. Brooks,
understand.
I'm going to mute you because we're off topic. We've gone over this time and time again.
No, I did that earlier, but I was printing a bunch of things and then.
So put on the record, Madam Clerk, what you believe you provided to Mr. Brooks already. All right, so he was provided with the packet of preliminary jury instructions. So let me I just need to add a line in here. I'll print this here for the state, and I'll print it in the other courtroom. There's a printer over there as soon as I do that. All right, I'm going to unmute Mr. Brooks for now. I was not looking at the monitor because I was sending the email to my clerk with that document, but I'd just like to get confirmation at least it was put in front of him on the table. Whether he accepts it or not, I understand, but Mr. Brooks, was that piece of paper placed in front of you?
I don't accept or consent to any paperwork.
Judge, I did see on the monitor the bailiff set some paperwork on the table in front of Mr. Brooks, and he took it off the table and set it on the floor next to him, it appeared.
All right, thank you for making that.
Accept or consent to that. I would
Mr.
not
Brooks.
accept any more paperwork.
All right,
period.
Mr. Brooks, you've made clear you're not going to accept paperwork, but we have an obligation, whether you make that statement or not, to provide you with copies of everything the court is addressing with the parties. So what you do with them is up to you. So your objection is noted.
You may be aware that certain things are not going to be awarded, especially when it comes to fairness.
Mr. Brooks, I need to move on to the jury instructions. Are you willing to participate in this process right now?
No, I am not. And I don't give consent without me being present in the courtroom, like I said before I was brought over here.
Would you like to come back over?
So why would you ask me now? Why would you ask me now?
Mr. Brooks, you were put over in that courtroom because of your disruptive behavior.
I
If you
wasn't
can
being
agree to
disruptive.
abide by the rules of decorum and courtesy,
I'm not gonna agree
then
to
I will
anything.
bring you back over here at any point in time.
I'm
Did
not
you
gonna
hear me
agree to
advise you
anything.
of that, sir?
No, I did not.
You're advised, sir, that if you want to come back to this courtroom, you may make a request at any point in time. If you come back, the court expects you to follow the rules of decorum and courtesy that you've previously been advised about.
So is how it's gonna be the whole trial? Every time I seek to understand
Mr. Brooks,
something
I'm
and ask a
offering you the
question?
opportunity to come back to this courtroom
I
to
just
participate
wanna know, 'cause
here.
I don't wanna go over there and then essentially have to come back right over here, because when I ask something that I don't understand, it's being looked at as me intentionally trying to disrupt the court.
Mr. Brooks,
sure-
I'm asking you a question. Please
I'll ask
answer.
you a question. I'll
Would
ask you a
you-
question as well, Your Honor.
Would you like to
I'll ask
come
you a
back to
question
the
as well.
main courtroom right now? Yes or no?
I asked you a question too, Your Honor. I asked.
All right,
is
I'm
this
going
gonna
to
be
mute
how it's
him.
gonna go?
I'm going to make a finding that his decision to not answer the court with a yes or no is non-responsive. Attorney Opper, will you or Attorney Basie be addressing the preliminary jury instructions?
I will, Your Honor.
All right, do you acknowledge receipt of those?
Yes.
All right, I will put on the record that the 68 pages were also provided to Mr. Brooks. What I intend to do is to read the following. This court is tasked with ensuring the orderly administration of the case. My job includes making sure that Mr. Brooks's rights are protected, making sure that the state and the defendant can present their respective cases in a coherent and orderly fashion, and that victims, witnesses, and the public are appropriately treated in the courtroom. There's a second part to the proposal that if at the time the court reads the preliminary jury instructions, Mr. Brooks is not in the courtroom, then to add the second where it says to be read only, that says at the moment Mr. Brooks is appearing from another courtroom, this must not influence your verdict in any manner. I understand Mr. Brooks is objecting. I'll give him an opportunity to make any statements regarding that on the record. I'll ask the state first whether there's any objection to inserting this in that location.
No objection to it. Inserting that, I would just note that in all of the jury instructions, I don't think we've ever mentioned Mr. Brooks by name. I think it's always been the defendant. I don't know if the court wants to be consistent. That was my only comment.
I think it would be good to be consistent. Mr. Brooks, I'm going to unmute you so that you can put the basis for your objection on the record.
Yeah, first of all, I'd like to state for the record that I'm pro per, not pro se. And what you just said about keeping it consistent, then it's been in this form ever since it was brought up. So why start to change the language and logistics of it now at this point to constitute me being in a separate location? If it's gonna be consistent, then it should be consistently as it was constructed. Nothing should be changed.
Sir, do you have, want to make any statement related to the jury instructions that I've provided to you, whether you object, consent, agree, or otherwise?
No, I don't consent. I do not.
All right, your lack of, sorry, go
I
ahead.
I just stated the reasons why.
Is that to
You
the
just
whole?
said so yourself, you just said so yourself, they need to be consistent. So why does anything need to be changed at this point? I also want to make
Small d.
state this on the record. You just referenced wanting to protect my rights, correct?
You have the language in front of you, sir.
Well, you just said on record that you will want to preserve my rights.
Mr. Brooks, you have the language of the jury instruction immediately on the screen in front of you. Do you have a question or a position on whether that's included?
I was getting to that. You did not let me finish. So it's not a question. Like I said, I was stating for the record. Part of protecting my rights would be the ability for me to inform the jury of the truth, their rights, and their duties under the First and Sixth Amendment.
Do you have a jury instruction that you would like me to read that would state that? Have you drafted anything, sir?
I wouldn't need to draft anything if it's already in the Constitution. I should be able to be afforded for those rights to be protected under the First and Sixth Amendment.
I'm sorry, I mistook what you were saying. I thought you wanted me to add a jury instruction, a written jury instruction, so that I would read something to the jurors. Am I mistaken on that?
It's clear that you're not grasping quite what I mean by what I'm saying. How about I draft something up and get it to you as soon as possible? Would that be sufficient for Your Honor?
If you draft something and submit it, and we have it by tomorrow morning, I can address that on the record, and whether it will be included or not. So yes, that's acceptable.
For the record, also may I state, and it's going back to the language that says pro se. Can that be changed to pro per?
That is a phrase that has meaning in Wisconsin law. It is accurate, and so your request to change it to pro per is denied.
Okay, how is it accurate?
That's my ruling, sir.
I don't understand, so I'm just seeking.
Mr. Brooks, that's my ruling. I need to finalize these, Mr. Brooks, I need to finalize these instructions.
Part of my rights being protected would be to be able to conduct my defense pro per, free from professional restrictions imposed upon licensed attorneys. That's another right that's not being protected.
If you're requesting that that language be included, the request is denied.
And is that a judicial determination that I won't have?
I do not believe that accurately states.
That right preserved?
I do not believe that that statement accurately reflects the law. All right, so we'll make the, Mr. Brooks, I'm moving on.
Can you show me by?
Mr. Brooks, I'm gonna mute you. Does the state approve of the jury instructions?
Yes.
All right, Mr. Brooks, I'm gonna ask you that question, actually two. Do you have any, and you're raising the objection, hold on, you're raising the objection sign, it's noted for the record.
I'm gonna continue doing it, that's the only way I can.
No, I know, and I'm making a record of it, sir. But we're at the point in time, do you have any requests for edits? Let me finish the question, sir. You're interrupting. All right, I'm gonna have to mute him again so that I can get my question out. Mr. Brooks, my question to you, do you have any other requests as it relates to edits, other instructions, or corrections of the 69-page instructions that you were provided with? And the added instruction that you were able to see on the screen. Go ahead, you are unmuted.
I wasn't looking at anything on the screen, and I already made clear on the record, and you just confirmed on the record that I will be able to draft something up and get it to you. So why can't I address anything in that draft?
Sir, I am
That would be
addressing
some
what
time.
we have now. So I will ask you now at this point, since you've not answered my question, I understand that you're going to draft something. Other than that, do you have any other edits, corrections, or requests for inclusion at this time related to these jury instructions?
Yeah, you still haven't answered if I'll be able to inform the jury of the truth, their rights, and their duties. That
Sir,
they have.
I have provided an answer to
I'm
that.
trying to finish.
All right, I'm going to object. I'm going to not object. I'm going to mute him again. I have told you you will have the opportunity to draft a proposed jury instruction for inclusion with this packet. At this point, he hasn't answered my question directly, and by his responses, I will make a finding that he's not responding. It's a non-response type of answer. As to what we specifically have before us today, do you have any objection?
Yes, I do.
Okay?
What prompted the change now, all of a sudden?
Because this is the time in the proceedings for the court to finalize those and to address any modifications. That's standard protocol.
So I'm still.
All right, your objection is noted, sir. I am approving everything that's in there. Mr. Brooks will still have an opportunity to submit any additional proposed instructions tomorrow morning, but at least we have this packet that's been approved